This is Judge Dedra Davis. We are here on March the seventh, 2025, with three of the Court 270's law clerks. They are going to introduce themselves. They're going to do their presentation on Rule 167.
Good afternoon, ladies and gentlemen. My name is Brian Mack Jr., and I'm at the University of Houston Law Center, and I am clerking with the Honorable Judge Dedra Davis at the 270th District Court, and I am joined by my colleagues Catherine Doris and Marlene Irigoyen, who will introduce themselves now.
Hi, I'm Catherine Doris. I'm a 2L at South Texas College of Law.
Hello, my name is Marlene Irigoyen, and I am a 2L at South Texas College of Law as well.
And we are here to discuss an often well-known but underutilized fee shifting provision in the Texas Rules of Civil Procedure, also known as Rule 167. In this presentation, we'll be going over the statutory origins of the rule. I will be providing a 1,000-foot view of the rule, generally speaking. Then I'll pass the torch to my colleague, Catherine, who will discuss settlement offers under the rule. And then Marlene will discuss awarding of fees and admissibility of evidence. Finally, we'll come together at the end to talk about subsequent reliance and advanced applications of the rule whenever an attorney wants to invoke Rule 167 to recover litigation costs. Now that I've provided an overview, let's answer the big question in the room. What is Rule 167? Rule 167 is a product of House Bill 4, which was passed in the 78th legislative session in 2003. House Bill 4 was a tort reform bill designed, among other things, to encourage more good faith attempts at settlement offers and dissuade litigation and unnecessary litigious behavior by providing a powerful cost shifting mechanism when an attorney offers A, to settle under Rule 167 and complies with the rule, B, opposing counsel rejects the settlement offer, and C, a substantially less favorable judgment is awarded to the rejecting attorney. In other words, it provides a powerful fee shifting mechanism for attorneys who might have settled but lost their cases. Now that I've talked briefly about the legislative mandate and Chapter 42 of the Texas Civil Practice Remedies Code, we'll see that Rule 167 mirrors the language of House Bill 4 and Chapter 42 of the Texas Civil Practice and Remedies Code and provides key deadlines in executing the rule. Now that we talked about the rule broadly, let's get into a mechanics from a 1,000-foot view. Firstly, there's a declaration of intent to settle under Rule 167 and Chapter 42 filed in the trial court, a settlement of the offer itself, a rejection or a settlement offer, a rejection of the settlement offer, and a significantly less favorable judgment. And finally, a motion to modify the significantly less favorable judgment for the offering party to recover their attorney's costs out of the judgment. Finally, let's get into what can be recovered under the rule, which is money, quite simply. It's reasonable litigation costs as defined by the rule, which includes court costs, reasonable attorney's fees, deposition costs, and reasonable fees for up to 2 experts. Now, let's go into the scope of Rule 167. Rule 167 is surprisingly broad and can cover any claim, cross-claim, counterclaim, or third-party claim. However, Rule 167 is not applicable in class action lawsuits, shareholder derivative actions, actions brought against the government, suits brought under the Texas Family Code, or Subtitle A, Title 5 of the Labor Code, or finally, an action brought in Justice of the Peace Court or any small claims court. So now that I've provided that 1,000-foot view of Rule 167, I pass the baton to my colleague Catherine, who will talk about settlement offers.
Thank you so much for the introduction, Brian. Once again, my name is Catherine Doris, a 2L at South Texas College of Law. And first, let's do a general overview about the 3 reasons why you should settle. First is efficiency. Civil courts are often overburdened by caseloads, and settlements help to free up the judicial resources. Second of all, cost reduction. As we all know, litigation is a very expensive process. Settlement provides a quick resolution without the need for costly discovery, attorney fees, expert witness fees, and so on. And third of all is certainty. Trials are always unpredictable, no matter how strong of a case a litigant has. Thus, settlement offers a more certain solution while allowing both parties to move forward without unnecessary hostility. More specifically, Rule 167 is underused by litigants, as mentioned by Brian, but it can be a very powerful tool as it provides cost-shifting incentives that can pressure opposing parties to settle. So now that we know why settlement is the preferred method of dispute resolution, let's discuss what is required to form a valid offer. A settlement offer may not be made until declared by a defendant. The declaration must be made no more than 45 days before the case is set for trial. Now, why do we require this prerequisite? Under Rule 167, cost-shifting penalties apply if a plaintiff rejects a qualifying settlement offer and later obtains a judgment that is less favorable than the rejected offer. Thus, a defendant's declaration confirms the intent to invoke the cost-shifting incentives. Furthermore, a settlement offer must be made in writing, state that it is under Rule 167 in Texas Civil Practice and Remedies Code Chapter 42, identify both the offeror and offeree, state all terms of the monetary claims, state an acceptance deadline, which cannot be less than 14 days after service of the offer, and be properly served to each and every offeree. Another requirement is that an offer's conditions must be reasonable and monetary. This is important because if a defendant attaches unreasonable conditions, the offer may be deemed invalid under Rule 167. Moreover, courts are likely to strike down offers that appear to be made in bad faith or that excessively burden the plaintiff. As long as conditions are related to the case, are non-coercive, and do not impose undue hardship, they will likely be upheld as reasonable under the rule. Now, pivoting over to the conditional time limitations. An offer may not be made before a defendant's declaration is filed, as previously mentioned, within 60 days after the appearance in the case of the offeror or offeree, whichever is later, within 14 days before the date the case is set for a conventional trial on the merits, except that an offer may be made within that period if it is in response to and within 7 days of the prior offer. The court does have discretion to amend the sub-rule when warranted. This is illustrated in Lewis v. Amica Mutual Insurance, where the judge ruled to ignore the 60-day waiting period for judicial efficiency's sake, as the parties had already participated in mediation and had sufficient information to settle. Now, once a valid offer is made, it must either be accepted, rejected, or withdrawn within the set time frame. A court cannot extend the deadline beyond what the rule allows, as doing so interferes with the statutory process designed to encourage settlements. Withdrawal. An offer can be withdrawn before it is accepted. Withdrawal is effective when written notice is served on the offeree. Once an unaccepted offer has been withdrawn, it cannot be accepted or be the basis for awarding litigation costs under this rule. Acceptance. Once an offer is accepted, the offer becomes binding and the offering party must comply unless a valid defense exists. An offer that has not been withdrawn can be accepted only by written notice served by served on the offeror by the deadline stated in the offer. And rejection. A settlement offer that is not withdrawn or accepted is automatically rejected. An offer may also be rejected by written notice served on the offeror by the deadline stated in the offer. And as previously mentioned, if a plaintiff rejects a valid settlement offer, they risk paying the defendant's litigation cost if the final judgment is less favorable than the offer. So rejections should be thoroughly considered. Lastly, a brief note on joinder. If the defendant makes a settlement offer before naming a responsible third party, the plaintiff can object to the offer within 15 days of that change. If the plaintiff properly objects, the offer won't count for shifting cost under Rule 167. And now I will pass it on to Marlon.
Thank you, Catherine. I'm Marlene Goyen, and as mentioned, I am a TULA at South Texas College of Law. So I will be breaking down the awarding of fees under Rule 167 to make it a little bit more digestible. I rephrase the general definition, which is when a settlement offer is rejected and final judgment on the case is significantly less favorable to the party. Give me one moment. Oh. The court will award the party that made the offer litigation costs against the other party. So a key term here is significantly less favorable, and that can depend on who it rejects the offer. So if the party bringing suit, which is the claimant, rejects the offer, loses, and the final judgment is less than 80% of the offer, or if the party being sued, which is a defendant, rejects the offer and final judgment is more than 120% of the offer. So as mentioned by my partner, Brian, he broke down what litigation costs is, but I just want to give y'all a refresher, which is court costs, reasonable depositions, reasonable fees for two testifying expert witnesses, and reasonable attorney's fees. And also, if defendant is awarded litigation costs, the cost is deducted from the amount the claimant won in the judgment. So limits on litigation costs, the rules have changed. So I broke it down into cases before September 1st, 2011 and after. Where we will be at is after September 1st, unless we have a really lengthy case. So before September 1st, litigation costs awarded must exceed non-economic damages, punitive or extra damages, half of the economic damages minus any liens that must be paid from the judgment. So there's a little bit of math involved in that one. And after, litigation costs awarded to any party must not exceed the total amount of what the claimant wins in the case before adding or subtracting any awarded legal costs. Okay, so now the no's of awarding fees versus double recovery, which just basically means that there's no double dipping. If a party can recover attorney's fees and litigation costs from another law, they cannot recover attorney's fees and litigation costs from Rule 167. They have to pick one or the other, but they cannot do both. And now onto attorney's fees. So the party that is able to recover litigation costs may recover attorney's fees as well, but the party who has to pay its litigation costs can't recover attorney's fees if they refuse the offer. Okay, now admissibility of evidence under Rule 167 is pretty simple. Evidence that enforces a settlement agreement or to recover litigation costs is only admissible if there's evidence that is just related to the settlement that cannot be admissible. And also, the jury may not know of the rule provisions, so this cannot be mentioned in front of the jury. Now I'm passing it on to my partner, Brian.
Thank you so much, Marlene, for talking about the awarding of fees under Rule 167. I'm Brian Mack again at the University of Houston Law Center. I will be talking about some of the more granular points of Rule 167 that didn't fit quite as neatly into this presentation. Firstly, if you are in San Antonio, this is incredibly important. A party must file their declaration of intent under chapter 42 of the Civil Practice Remedies Code and Rule 167 before they extend a settlement offer. And we see this in the Medfin Manager LLC versus Salas case. Secondly, on awarding fees, non-suits would not trigger Rule 167 as we see in the Mahaffey v. Washburn case, where the judge in that case held that because it's a non-suit and the party would be awarded zero damages, there's only $0 for the attorney to plea and recover costs from. And even a more granular point regarding the Lone Star method of calculating damages. The case United Parcel Service Incorporated v. Rankin held that a judge's decision to apply a lodestar multiplier to attorney's fees is well within their discretion, meaning that if the judge rejects an attorney's plea to apply a lodestar multiplier to their attorney's fees, it's not something that can be appealed. Finally, Rule 167 settlement offers can cover unpled claims if they resolve the underlying dispute. In other words, a claim doesn't need to formally be enumerated in the plaintiff's or defense's pleadings in order to have it listed in the settlement offer. And now that we've gotten the more advanced applications and granular points out of the way of Rule 167, we have summed up for you today the statutory origins of the rule, a rule 1,000-foot view of the rule, as I discussed generally. Then Catherine talked about settlement offers under the rule before passing the baton to Marlene, who talked about awarding of fees and admissibility, where I concluded on the more advanced applications and other considerations of the rule. I just want to say thank you so much for tuning in and hearing our conversation about Rule 167. And we're more than welcome to answer any questions for the people in the courtroom today.
Thank you. Thank you very much. Introduce yourselves one more time.
I am Marlene Irigoyen. I'm a 2L at South Texas College of Law. Thank you so much for your time.
And once again, I'm Catherine Doris, a 2L at South Texas College of Law. Thank you for having me today.
Thank you so much. I'm Ryan McInerney from the University of Houston Law Center as well. I'm the 2L.
Thank you.
Thank you. You all did a wonderful job. Thank you.
Thank you.